Okay, that is the cultural consideration, the first part of this lecture. In this second part, we are going to discuss on the legal and ethical considerations with regards to psychological assessment. As an overview, in these subtopics, we are going to look into three main discussion points. Okay, the first is the concerns of the public. The second is the concerns of the professions. And the last one, the rights of test taker. Under the concerns of the public, we are going to look at three important aspects. First, awareness, worry, and needs towards psychological assessment. Second, we are going to discuss about how psychological assessment related to legislation as well as litigation. Okay, both involve the aspect of law. And in the second part, we are going to discuss four factors which are concerns of the professions, which are test user qualifications, testing people with disabilities, computerized tests, as well as guidelines for specific population. And in the last part of this lecture, we are going to look into another four main discussion points under the rights of test taker. First, we are going to discuss about informed consent, and then followed by the rights for knowing test findings, followed by privacy and confidentiality, and lastly, we are going to discuss about the least stigmatizing label. Okay, first and foremost, when we talk about legal and ethical considerations, we need to understand important concepts in legal and ethical perspective. First one is law. So what is law? Law are rules that individuals must obey for the good of the society as a whole. So it's basically rules that everyone have to follow. In other words, rules thought to be for the good of society as well. Okay, not only is good but must be seen as good for society as a whole. So some laws are made have been relatively uncontroversial because law sometimes relate to principle as well. But we have to admit that even nowadays, there are some laws are quite controversial. Okay. If you are reading through the case, the political cases which involve in Malaysia, for examples, I was surprised at one time when one of current minister who has been jailed. Why? Because he was the whistleblower of one cases related to government officer. Okay, I do not know at that time that if you disclose important information of a company which the company regards as official or confidential information to public or even to police department, you may be charged as intervening or holding false or not false information, holding confidential information. So in this case, even though the actions of the officer of the representative is good, but the law dictate that he should not possess those information, even though what he was doing was correct. So this kind of law is quite controversial. In one way, this person try to protect, protect the interests of the society, the interests of the nation, but at the same time, the law dictate that he should not disclose that information, and in fact, he should not even obtain those information at the first place. Okay, whereas a body of laws is a body of rules, a body of ethics is a body of principles, principles of right, principles of proper, principle of good conduct. Okay, so there is slight differences between ethics and legal perspectives. Ethics here refers to a body of principles. Examples of ethics. Okay, example of ethics in academic field, for example, the ethics of journalism. Okay, in journalism, reporters present all sides of controversial issues. Okay, they should not be choosing sides. Okay, they should not be choosing owners. When they report on any issues, they should report on both perspectives. Okay, similar thing applicable in the context of research. A principle of ethical research, for example, the researcher should never fudge data. Okay, all data must be reported accurately. Okay, you cannot manipulate, you cannot fabricate any data. So that is a principle in ethical research. So when we talk about legal and ethical considerations, which contains laws, which also contains principles, we also need to understand code of professional ethics. Okay, when you read through books, okay, or even you look at company policies, you will come across a lot of document which mention code of conduct. So it's applicable similarly here. So a code of professional ethics refers to sets of rules or guidelines that professionals agree to follow. Okay, so when you are psychologists, when you are lawyers, when you are medical officers, okay, you are doctors, so you are bound by your professional code of conduct or code of ethics, because that your profession already subscribed to that guideline. So everyone have to follow. When this code is recognized, okay, when this professional ethics is accepted by the members of the profession, so this code set the standards of care. Okay, how should we behave? How should we conduct ourselves? This means this code of conduct, this code of professional ethics determine what is expected of us in our work, in our job. Okay, what is expected of us if we are clinical psychologists? What is expected of us if we are psychometrician? What is expected of us if we are the psychological assessment professionals? So the term standard of care here refers to the level of service. Okay, refers to the level of service that an average, a reasonable, and a careful professional would provide under the same or similar conditions. So basically, it refers to quality of our service. In other words, it is the quality of services you would expect from a professional who is doing their job properly. And this could be providing diagnosis or therapy to others. Okay, providing diagnostic or therapeutic services. When we talk about legal and ethical considerations, these two aspects affect everyone. Okay, regardless of your profession, regardless of your jobs, regardless of your society rules in your society. However, in this context, members of the public, the society, okay, laymen, and members of the professions, which is the professional in psychological assessment, have not always been on the same side of the fence with respect to the issues of ethics and law. Okay, in other words, publics, okay, people or laymen, people in our society, member of our society, they concerns different things, and their concerns is not similar to the concerns of other psychological assessment professional or psychometricians with regards to legal and ethical consideration. Okay, they focus on different things. First, let's look at public concerns. Okay, what are the concerns of the public with regards to psychological assessment from legal and ethical perspective? Okay, public concerns on psychological assessment develops from awareness, worriness, and needs. Okay, at first, people have very limited knowledge on the usefulness and utility as well as application of psychological assessment in their lives. Okay, concerns about the use of psychological tests started after World War I. Okay, when tests developed for military use were adapted in school and industry. Okay, originally people developed these tests to select army personnel and to assign them to different departments for different roles. But this test has been adapted and used in schools, okay, to select or to identify intelligence levels among students and to design what are the supports that they need, for example, as well as to select employees to work in a certain industry or in the certain positions. Okay, so there is a concern here because there are people who support the use of these systematic tests so that they have evidence. Okay, they have a concrete guideline on how to assign people to accept or to reject or to recommend or not. Okay, people based on their test score. But however, at the same time, there are some group of people feel that this approach is too mechanical, which undermine the dynamics of learning and education. Some people, they are early developers. Some people, they are late bloomers. Okay, for the late bloomers, when they answer this side of test has been regarded or labeled as low learner, it will hinder their potential in their later age. This awareness and worriness later turns into needs, especially after the launch of Sputnik by the Soviet Union. Okay, Sputnik here is Soviet Unions. They launched the satellite with circling the Earth. Okay, at that time, people feel that their safety, their security might be at risk. Okay, why? Because they are foreign agents which keep on looking at them. Okay, these aspects have made people aware on the importance of developing our young children who have high level of intellectual ability, geniuses, people who are gifted in their learning. Okay, these people should have different learning approach, should be polished. Okay, their talent should be polished, and government should make use of their giftedness. Okay, so what happens after the launch of Sputnik by the Soviet Union is prompted the US government to increase testing of abilities and aptitudes in school. Why? To identify talented students. Okay, so these students can be channels to a high level kind of thinking and program so that they can maximize their talents for the purpose or the betterment of the nation. Okay, simultaneously, ability and personality testing greatly increase in government, in military, as well as in business. And during this era, it has led to renewed public concerns, okay, especially in 1969 when Arthur Jensen published an article titled "How Much Can We Boost IQ and Scholastic Achievement?" Okay, so why this has become a noticeable historical event? Because Jensen suggested in his article that genetic factors are strongly implicated in the average Negro white intelligence difference. So basically, why there are some people in a different colors of group, okay, group of colors, okay, people in black and white people and black people different in intelligence because of their genetic difference. So Jensen's work caused renewed public concerns over the nature versus nurture issues that we discussed before this, and what intelligence tests really measure. So people keep on arguing back the everlasting dilemma, the everlasting debates on whether intelligence is something innate that we are born with, or we can develop and learn our intellectual ability or intelligence. So in recent decades, the government has been extensively involved in various aspects of assessment, okay, including in education, including in public service, including in health, and including in military and safety. So those are the awareness, worry, and needs of public concern with regards to psychological assessment. And these concerns later relates to legislation. Okay, both legislation at the federal and state levels may affect the assessment practices. Okay, because law dictates what people can do and cannot do. Okay, for examples, after the government, in this case, the United States governments introducing the minimal competency testing programs in the 1970s, many states passed laws to ensure that high school graduates should be able to meet minimal competencies in reading, writing, and arithmetic. In other words, if a school children do not develop these three skills, reading, writing, and arithmetic, they should not be allowed to graduate from the schools. Okay, why? Because these law, minimal competency testing programs, dictate that all graduates must have minimal competencies. And during this time as well, legislation has been passed down that dictate what people can do and how people should utilize psychological assessment. For example, truth in testing legislation. Okay, this law has been passed at the state level in the beginning of the 1980s. Okay, the objective of this law, truth in testing legislation, to give test taker a way or an opportunity to learn the criteria by which they are being judged. So basically, people have the rights to know, the rights to learn what are the criteria that they are being evaluated or they are being judged by the courts. Okay, so if you look through, especially in our textbook, there are quite a number of legislation which concerns the application of psychological assessment and psychological testing. Okay, there are a lot of it. So I'm not going to cover everything because most of which are not applicable in Malaysian context. Okay, another example here, the Civil Rights Act of 1964 created the Equal Employment Opportunity Commissions. Okay, so these acts influence, okay, the establishment of this commission to enforce this Civil Rights Act. So this EEOC, okay, commission has published a set of guidelines concerning standards to be met in constructing and using employment tests. So basically, company or organization cannot simply use or develop their test out of nothing. So they must follow the EEOC guidelines. In one of the initiatives of this guideline is to prevent discriminatory testing practices during employment. So they don't want to discriminate any group of people or gender or nationality or any political orientations. So there is a public demand for proportional representation in hiring and school acceptance. Okay, yet there are still gaps in test performance by various groups. So when they have any form of testing, okay, especially in hiring school acceptance, so one of the demands by the public is to make sure they must be representative from all group of peoples, different races, different genders, different tribe, okay, different colors, for example, to make sure all of their needs and concerns are taken care of by the test itself. So some scholars, have argued that if tests are valid and useful, they should not be changed or dismissed, but rather the skill gap should be addressed. Okay, there is a concern here. When you require representation from all different types of group in the society to be in the commissions, to have a say on the testing, it shows that this test might not be valid. If the test is valid and reliable, the test should not be changed. Okay, even though the test indicates there is a big gap between white and black, for example, between Malay and Chinese, for example, between Chinese and Indian, for example. If there is a big gap between different ethnicity, different group of people, what we need to do is to address the gap. okay, to train the people who score low on the test, not to change the test itself. So beside legislation, the law itself, litigation also play important roles in legal perspectives. So the difference between legislation and litigation, legislation is the law, litigation is the case brought to court and how the court pass down the judgment. So basically we know that the past judgment or court precedents can be used as the reference point as well, or as the law itself. So a lot of reference points or litigation cases in court has been referred to see how courts see certain cases with regards to psychological assessment. So here are a few examples that when the courts pass the judgment, it concerns the psychological assessment aspects in everyday life or in public's living. For example, the case of Spark, P-A-R-C, versus Commonwealth of Pennsylvania 1971 and Mills versus Board of Education of District of Columbia 1972. Okay, these cases prompted Congress to ensure appropriate educational opportunities for children with disabilities. So here in this judgment, it shows that people or higher or education provider need to make sure that equal opportunity are assured, are confirmed to the people who have these disabilities or children with disabilities. So psychologists in this sense may act as expert witnesses. Okay, psychologists can be considered as expert witness in civil as well as criminal cases. So in 1923, in the case of Fryer versus the United States government, in this case, in the judgment, in the precedent itself, established that scientific research, including research using psychological assessment or psychological tool or psychological testing, is admissible as an evidence when the research study or methods enjoy general acceptance. So general acceptance here is a key point. Okay, so if any cases they are brought to courts and then the lawyers cited famous research findings from scientific research, from empirical study. So those research can be admissible as an evidence. So general acceptance here could be typically be established by the testimony of experts themselves or and by reference of publications in peer-reviewed journals. Okay, so this is how the court established general acceptance of the scientific research as an evidence. Okay, so here the case of Fryer versus United States, you have to pay attention to this because there are other cases which come later. Okay, for example, the case of Daubert versus Merrill Dow Pharmaceuticals. In these rulings, the Supreme Court supersedes the long-standing policy set forth by the Fryer, we just mentioned just now, of admitting into evidence only scientific testimony that had won general acceptance in the scientific community. Okay, by now you have realized that there are a lot of research conducted on a certain aspect. Okay, so what are the concerns of the court? Only research that have received general acceptance can be admitted as scientific research evidence. Okay, however, this is not the same in this case of Daubert versus Merrill Dow Pharmaceuticals. Okay, in this aspect, an expert opinions or evidence that contradicts another expert opinions can be considered or even allowed, regardless of whether this opposing opinion is widely accepted by other experts in the same field or not. Okay, given examples. Okay, there are a case, and the prosecutor bring in one empirical research, Okay, one empirical research, and this empirical research is generally accepted. Okay, however, the defendant themselves can bring another research that counter the findings reported by the research, by the study bring about by the prosecutor. Okay, in this case, there are two research contradicting, and both can be accepted by the courts. Okay, the Daubert ruling gave trial judge more leeway, more opportunity, more freedom in deciding which testimony should be heard by the jury. Okay, so some jurisdiction still rely on the Friar standard when it comes to the admitting expert testimony, which are generally accepted, and even some expert or some subscribe to the Daubert, whereby you can even consider the less famous or less known research, as long as you can, it depend on a proper empirical study. So these are the three concerns among public. Okay, awareness, worry, and needs of psychological assessments. Okay, the issues of law and legislations, and the issues of litigation. Okay, all of these relate to the application, usage, and acknowledgement of psychological assessment and its finding. Okay, these concern the public. On the other hand, people in psychological assessment professions, psychometricians, professional in psychological assessment, they look into different aspects when we talk about legal and ethical perspective. Okay, legal and ethical considerations. Okay, for example, professions, okay, or professional in psychological assessments, they concerns about test user qualification. Okay, test user qualifications in 1950, an APA Committee on Ethical Standards for Psychology, they published a report. Okay, this report calls Ethical Standards for the Distribution of Psychological Tests and Diagnostic Aids. Okay, so what these standards stand for? So this report, which introduced these ethical standards, they outline 3 levels of tests in terms of expertise. Okay, so basically they categorize professional in psychological assessment into 3 categories. Okay, they call it level A, level B, and level C. So how they differentiate professional of assessment or psychometrician as a level A? So people in level A, people in this category, if they use tests or aids that can adequately be administered or scored and interpreted with the aid of the manual only. Okay, people who have the expertise, they don't need to go to extra classes or to take a certificates or go for specialized training. It's enough for them when they purchase a test. When they want to use the test, they read the manual, they can understand it correctly, they can administer it accurately, and they can interpret it correctly. Okay, so these are the level A of psychological profession, of the assessment professionals. They are level B. So in level B, tests or aids that requires some technical knowledge of test construction and of supporting psychological and educational fields. Okay, in this aspect, if you are awarded level B, okay, by reading the manual only to administer, to use a test is not enough. Okay, so you require some technical knowledge, okay, of test construction and supporting psychological or educational field. So you need further training. Okay, you need further workshops. Okay, you need further, you need to go through or earn some certificates to be able to do this. Okay, this is more serious, or not more serious, is basically in a long way similar to level C. Okay, tests and aids that require substantial, in no longer some. Okay, in level B, some technical knowledge. In level C, substantial understanding of testing and supporting psychological fields together with supervised experience in the use of these devices. Okay, not only that they require further trainings, okay, require specific certificates, but they also need to be supervised when they are administering or using the test. So basically, APA, even in 1950s, have differentiates three types of professional in assessment: level A, level B, and level C. Okay, that is the first concerns among assessment professional, okay, psychometricians, which is the test user qualifications. Another one of the main concerns among the professional is testing people with disabilities. So we don't want to discriminate any group of people, including people with disabilities. So there are admittedly challenges when we want to conduct assessment with people with disabilities. So these are the three most common challenges in testing with people that have disability. The first one, transforming the test into a form that can be taken by the test taker. I think I've touched this a little bit in class before. So it's part of the ethical conduct, the rights of the test takers. If they are disabled in some way, we need to adapt the test to make sure that the test taker, in this case people with disabilities, would be able to give their response, would be able to answer the test. So we need to transform the test into a form that can be taken by the test taker. Okay, it sounds simple, but sometimes the tests go beyond than their capacities. Examples, tests that require you to identify patterns, to identify uniqueness. But if your participants have visions issues, so they cannot see or they're blind, so they might be struggle or they can't even participate in this particular test. So it's a big challenge to transform this kind of test into a form that they can answer. Second challenge, transforming the responses of the test taker so that they are scorable. Okay, they can be marked. Okay, we can score them. Okay, sometimes you can even change. Okay, you give a paper and pencil test to a group of disabled person. They cannot read, so you can ask your helper, in this case research assistant, okay, test administrator, to help you read to them. Okay, read the answer option to them, and you can require or acquire their response through this verbal conversation. Okay, here if they have vision only, they can still speak. Then it's basically they can say, okay, strongly disagree, it's 1 or A or B or T or C. So they can respond in that way. How about people who have both problems? Okay, they cannot see and they also cannot speak. So in this case, you need to be able to transform their responses to the test of the test taker so that their response are scorable. Okay, for example, if they can listen, okay, if they prefer A, so they need to hold a card that they hold in their right hand. Okay, or they can knock on the table once. If the answer is B, they can knock on the table twice, for example. So after that, you transform their response into the survey or questionnaire itself. And third challenge is meaningfully interpreting the test data. Okay, you have to bear in mind their conditions, their situations, and their ability. Okay, so you cannot regard the similar aspect of them with the normal test taker. Okay, similar level. So we must be, okay, their condition and situation must be taken into consideration when you want to interpret their score. Okay, one particular policy, okay, with regards to testing people with disabilities, you can see under the Oregon's Deaf with Dignity Act. Okay, this is basically mercy suicide. Okay, people who want to terminate or want to commit suicide through medical procedures. So terminally ill patients requesting assistance dying, they must first have a psychological evaluation. Okay, because we afraid that when they make those decisions are not made when they are at their normal states. Okay, they have depressions, or they have manic attack, or they have been influenced by delusion or hallucination. So under this Act and Oregon's Death with Dignity Act, all people who requested this service, okay, assistant dying, must first have a psychological evaluation on their mental state. Besides test user qualifications and testing people with disabilities, professional in psychological assessment, psychometrician for example, they also concerns with computerized test administration, scoring and interpretation. Okay, given the development in this technology, okay, the Internet of Things, globalization, for example, the outreach, okay, the application of Internet, okay, world or web also very rampant. So a number of psychological tests nowadays can be purchased on this or administered as well as scored online. So we don't depend solely on the paper and pencil test. So these forms of psychological tests offer convenience, offer simplicity, and offer greater range of assessment. So without a doubt, with the digital form of psychological test, it does give a lot of advantages to the test user. However, there are also concerns with the online or digital form of psychological test. So these issues is explained in the computer assisted psychological assessment issues. Okay, so there are three main particular issues which regard to the digitalized or computerized test administration, scoring and interpretation. The first one, when we use the digital form, the online form of the test, they could raise the issues of comparability of pencil and paper as well as computer test. Okay, we want to have the test, even though with different form, paper and pencil, as well as computer test, to give the same indication of the psychological variable under investigation. So we do not want, if a person answer a paper and pencil format, they perform better as compared to if they are answering the digital format, vice versa. So we want to have a comparability in terms of the finding and score. The second issues with regards to computer assisted psychological assessment is the value of computerized test interpretation. Okay, so we have to admit now that with this rampant development of this technology and increased awareness of psychological assessment, people start to use a self-administered, okay, even unqualified websites to self-diagnose themselves. Okay, sometimes the value of computerized test interpretations has not been the same as compared to if you have to meet psychological assessment professionals. Okay, why? Because the usage of this could devalue or reduce the value of test interpretation. We have to be aware that when we depend on digital form only, for example, just answering the test online, we can only get a very superficial interpretation of the test. Okay, why? If we meet professional, we meet therapists, we meet counselors, we meet clinical psychologists, they, beside looking at our score, they can also look, depend back on their expertise, look into their observation, and relates back to their experience. Excuse me. So therefore, the value of computerized test interpretation should be maintained. Okay, not to reduce or devalue when people use computer-based testing. And another issues with regard to computerized test administration, scoring, and interpretation is unprofessional, unregulated psychological testing online. Okay, based on my own experience previously, I've noticed that there are some companies without proper qualifications offer psychological assessment online. Okay, there are number of issues surrounding this practice. One, they don't have the qualification. Remember, the first concerns of professional in this profession is the qualifications of the test user. First, they don't have a proper qualification. Sometimes they do have degree or bachelor degree or master degrees, but they are not familiar with a certain test. But they still provide this test. Okay, they digitalize some tests and they provide this service. Secondly, there are a lot of tests available online are pseudo-psychology or are not based on scientific research. So they're based on popularity. Okay, they're based on demands. Okay, they're based on the pop culture at that particular times. So there are numbers of so-called unprofessional, unregulated psychological testing provided online. These are very difficult to be regulated because people who operated them are not qualified, are not bound to any psychology or any association or authority. Beside these computerized test administrations, the last concern in profession, okay, among psychological assessment professionals, among psychometricians, among psychologists, okay, they also concerned with guidelines, okay, guidelines for specific population. Okay, from time to time, the APA, American Psychological Association, has published special guidelines for certain population. Okay, remember culture-specific tests. Okay, sometimes they develop a specific test for a certain culture. And then even there are some general tests or universal tests, they may need special guidelines or manual of administration when test user want to use it in their own context, in their own cultural context. So in general, these guidelines are designed to assist us, okay, to assist professionals in providing informed and developmentally appropriate services. Because why? Certain culture have different values, different norms, different practice, different traditions, and the result could be interpreted in different way. So examples of specific guidelines developed by APA throughout these years. The first one, APA guidelines for assessment and intervention with person with disabilities. So this guideline revised in 2022. Another one, APA guidelines for psychological practice with sexual minority persons. This is revised 2021. Okay, previously they used the terminology such as lesbian, gay, and bisexual or LGBT. But after the revision of 2021, it's renamed with sexual minority persons. And another guidelines which are specifically developed for a certain group of population is APA updates guideline on psychiatric evaluation in adults. Okay, so those are basically the concerns, the four concerns of the profession. Test user qualifications, testing people with disabilities, computerized tests, and guidelines for specific populations. So beside the concerns of the public, as well as the concerns of the professions, we also look after the concerns of the test taker. Okay, under the title of test takers rights. Okay, the first test taker right is informed consent, the right of informed consent. So test taker, okay, our participants or maybe our clients, so test taker have a right to know why they are being evaluated, okay, why they are being tested, okay, why they are being assessed, how the test data will be used, and what, if any, what information will be released and to whom. So basically, test taker have the rights to know why they are being assessed, okay, how the test data will be used later, and what information will be released and to whom will receive the result. So basically, we need to inform our test takers, our participant, our client about this, and we have to acquire their consent. If informed only without consent, then we still do not fulfill the right of informed consent to our client or to our test takers. So informed consent. So test takers should give their informed consent only with full knowledge of such information. So what are these information? Information of why they are being evaluated, information of how the test will be used, okay, and what are the information will be released and to whom. So information needed for consent must be in the language the test taker can understand. Okay. For example, most of you familiar with tests or psychological tests or survey or measure or inventory, which is developed in English. So you are comfortable to answer in English. But it's not so applicable for those who are not so proficient in English. So if they don't really understand English, so informed consent must be conducted in the language that he familiar with. For example, Bahasa Melayu or Mandarin or Tamil. Okay, so some groups, okay, for example, people who have dementia, people who suffer from bipolar disorders and schizophrenia, for examples, they may not have the capacity, okay, in this case, the mental capacity or the competency to provide the informed consent. Even if you ask them to give informed consent, okay, to inform and get their consents, so it may not be valid. Why? Because at that particular time, they are not capable or they don't have the competency to give the consent. So if competency cannot be provided by the test taker himself or herself, so the consent must be obtained from a parent or legal representation or legal guardian. So we cannot run away. We still need to ask for informed consent. So the components of competency includes, first one should be able to show or to prove their decisions about whether or not they want to be involved in the test. Okay, this could be relevant in many situations where consents or agreements to be involved is important. Okay, in the case of testing as well as assessment. So demonstrating a factual understanding of the issue. So this is the second component of competency which required on behalf of the test taker. First, they need to show or prove that their decisions about whether they want to join or they don't want to join. Second, they demonstrate a factual understanding of the issue. They know why, they know when, they know what, for example. And another component of competency includes being able to reason about the facts of the study or the facts of treatment or whatever it is to which consent is required. Okay, so they know. Okay, they know how to explain. They know the reason, okay, the justification behind the reason why we need to acquire the informed consent. And last components of competency is appreciating the nature of the situation. So they are basically aware of their situation and their conditions at that particular times. So these four are the components of competencies which are required on behalf of the test taker when we go and approach them, inform them, and acquire their consent. So all of these under the first rights of our test takers, which is the right of informed consent. So beside acquiring their consents after being informed about the test, we also need to realize that the test taker have the rights to know or the rights to be informed of the test findings. Okay, what happened? Most of the times when we conduct any assessment or test, so after we get data, we keep silent. Okay, we don't even inform or give feedback to the test takers. Okay, we need to be aware that their rights to know about their results. So in the past, test takers were often not informed of their diagnostic findings or anything that might hurt their self-image. That was in the past. But currently, giving information about test performance to examinees is ethically and legally mandated and may be useful for themselves from a therapeutic perspective as well. So basically, we have to inform them. Okay, it's ethically and legally mandated. So test takers have a right to know about test findings and recommendation of what they need to do about the results. So test users, which is us, should sensitively inform test takers of the purpose of the test, the meaning of the score relative to those of other test takers, and the possible limitation and margins of errors of the test. So we should inform, and we should be careful when we want to inform, okay, so that we are not going to deter, okay, their self-confidence, or we are not going to make their current status or current state even worse. So we have to be sensitive on when we want to inform about their findings. So we need to inform about the meaning of the test, okay, as compared to other test takers. Okay, what are their standing? What are their status? Okay, is there any possible limitation of the test? Okay, maybe it could be a false positive. Okay, you may suggest to them to have a second opinion, to take another test, or to retake the test again. And is there any percentage or margin of errors with regards to the validity of the result? Another important test taker's rights is related to privacy and confidentiality of information and data. So test taker have the rights to privacy and confidentiality. So here, the concepts of the privacy rights recognizes the freedoms of the individual to pick and choose for himself the time, circumstances, and particularly the extent to which he wishes to share or not to share. Okay, to share or withhold from others, including the test users, including the therapists, including the counselors, about his attitudes, about his belief, about his behavior, and about his opinion. So basically, they have the freedom, okay, whether they want to participate or not, whether they want to cooperate or not, or whether they want to answer the questions or not. It's basically their right. So in most states in the United States, information provided by clients to psychologists is considered as privileged information. Okay, so privilege in this sense is not absolute. Okay, it's not 100% the privileged information. Okay, so it's not absolute. Psychologists may have to disclose information, even though it's a privileged information. There are circumstances, there are situations where require psychologists to disclose information that they get from the test taker. Okay, so psychologists may have to disclose information if it will prevent harm either to the client or to some endangered third party. Example, so you are conducting a suicidal ideation, for example, among school children, okay, teenagers, and then you found out they are test takers, in this case school children, who have a very high score for suicidal ideations. So there is high tendency for these children to commit suicide. So it's become an obligation for you to inform or take a precautions by informing and discussing with their parents, for example, or their guardians. Okay, a privilege in the psychologist-client relationships belong to the client. Okay, you have to remember this. It's not belong to the psychologist. It's belong to the client. So clients can direct psychologists to disclose information to other third party. Okay, for example, they want to claim for their insurance. Okay, or they want to justify with their attorney. So in this case, client can order us, okay, can direct us, can instruct us to disclose information to them. Okay, psychologists also obligated to make the disclosure. In some rare instances, the psychologist may ethically, if not even legally, compel to disclose information if that information will prevent harm either to the client or to some endangered third party. Okay, it's similar to previous one. So basically, we are obligated to disclose information if the client demonstrates high tendency for suicide, for example, high tendency for social path, going to hurt someone else, for example. So all of these relates to the privileged information, which at the first place is not obsolete. Okay, all of these involve with the confidentiality of the information. So confidentiality may be distinguished from privilege in that whereas confidentiality concerns matters of communication. Okay, so we do not go and talk about the situation to others. Okay, this confidentiality matters of communication outside of the courtroom, while privilege protect clients from disclosure in judicial proceeding or in court. Okay, so that is about privacy and confidentiality, one of the right of test takers. The last right of test takers that we need to consider in psychological assessment is least stigmatizing level. Okay, stigmatizing here refers to words, refers to terminologies that when we inform or when we regard someone might incur a negative or a discriminatory reactions among people. Okay, so the standards advise that the least stigmatizing level should always be assigned when reporting test results. So we should avoid terminologies or words that may incur discrimination or stigma among people. For example, slow learner, okay, stupid, idiot. Instead, what we can see, the score of this person for intelligence test is less than average or below average. So we do not give a label that might stigmatize or might discriminate them in the society. Okay, so those are everything that we need to discuss in the first and second part of this chapter. Cultural and legal / ethical consideration in psychological assessment. So in the first part, so we talk about culture and assessment, okay, the evolving interest in psychological assessment, issues regarding culture and assessment, okay, the verbal, the non-verbal, and the standard of evaluation. And we talk about test and group membership, where we discuss more on the affirmative action. The second part, we discuss a lot from legal and ethical considerations that test users need to consider before they administer or use the test. So we talk about the concerns of the public, okay, where the worry, the needs come from. Okay, the issues of law, okay, the legality of it, okay, the litigation of it. Okay, and then we discuss about the concerns of the profession, okay, the professional of psychological assessment. Okay, they are concerned about the qualifications. Okay, they concerned about the people with disabilities. Okay, they concerned about computerized tests, and they concerned about guidelines. Okay, guidelines for specific population. And just now we just completed discussing about the right of test takers. Okay, right for informed consent, right to be informed about the finding of the test. Okay, rights for confidentiality as well as confidentiality and privilege of their information. Okay, and the rights to not to be labeled with something that can stigmatize or discriminate self in the society. So all of these that we have discussed, and thank you very much for your attention, and see you guys in the next video.